Supreme Court under Article 124 to 147, Part 5. So we have in India integrated judicial system with the Supreme Court at the top and the High Court below it. Under a High Court, there is a hierarchy of subordinate courts, that is district court, etc. This single system of court is adopted from Government of India Act of 1935, enforces both central law as well as state law. Supreme Court was inaugurated on January 28, 1950. It succeeded the Federal Court, which was set up by Government of India Act of 1935. At present, Supreme Court has 33 judges, including Chief Justice of India. Originally, the strength of Supreme Court was fixed at 7. The Parliament has the power to increase the number of judges in the Supreme Court under Article 124C. Appointment of the judges is given under Article 126. The judges are appointed by the President with the consultation of Chief Justice of India. Okay. There are multiple cases with the appointment of judges, which is first judge case 1982. Says consultation of India is not consultation of CJI is not binding on President. Second judge case 1993, consultation of CJI is binding on the President. Second judge case 1993 says कि consultation of CJI is binding on the President, and this consent is called concurrence. And in third judge case of 1998, consultation must be included. Um, Consultation of CGI is converted into collegium system. Okay, which is the four senior most judges of Supreme Court, including Chief Justice of India, and the consultation is now converted to concurrence, but not written as concurrence. It is written as consultation, which is binding on the President. 99th Constitutional Amendment Act of 2014 introduced NJAC, National Judicial Appointment Commission, for appointing judges, replacing collegium system. But in 2015, Supreme Court made it unconstitutional and void. In second judge case of 1993, Supreme Court ruled that the senior most judge to be the CJI of India. In second judge case 1993, Supreme Court ruled that the senior most judge to be the CJI of India. Qualification of judges. First, he should be the citizen of India, and he should have been a judge of a high court for 5 years, or have been an advocate of a high court for 10 years, or a distinguished jurist. He take oath before the President. The tenure is not fixed. He can act until he turn to the age of 65. Okay, he can resign writing. He can resign with writing letter to the President. He can be removed by the President through a parliamentary resolution passed by a special majority in the each house. The Judge Inquiry Act of 1968 provides the resolution must be presented in the House if signed by 100 members in Lok Sabha or 50 members in Rajya Sabha. Speaker chairman may admit or refuse the motion. If admitted, Speaker and Chairman constitute a 3-member committee, which includes CJI, Chief Justice of a High Court, and a distinguished jurist for investigation. And final action is taken by the President. Salaries and allowances are determined by the Parliament and can't be altered during the tenure except during national emergency. This is given under Article 125. The President can appoint a judge of Supreme Court as an acting CJI if the seat is vacant for temporarily. This is given under Article 126. Ad hoc judges are appointed by CJI to fill the lack of quorum of judges. Judges of High Court are appointed as ad hoc judges. Article given under Article 127. Chief Justice of India can appoint the seat of Supreme Court at any place in India after approval of the President. Okay. The President can appoint a judge of Supreme Court as an acting CJI if seat is vacant temporarily. This is given under Article 126. Jurisdiction and powers of Supreme Court. Supreme Court has original jurisdiction, which is given under Article 131. This deals with disputes between center and state, center and a state, center and one or more states, states and a dispute between multiple states. The jurisdiction doesn't extend to a dispute arising on treaty, agreement, covenant, and such and other such instruments, and on agreements with which exclude jurisdiction on interstate water dispute, matters related to the Finance Commission, etc. Second is writ jurisdiction. This is given under Article 32, and Supreme Court can issue writs for enforcement of fundamental rights. Third is appellate jurisdiction. Appellate jurisdiction on constitutional matters, and under Article 132 from High Court, and under Article 133 from civil matters, and Article 134 for criminal matters. Appeal by special leave is given under Article 136. Advisory jurisdiction is given under Article 143. Authorize the President to seek the opinion of the Supreme Court in two matters: on any questions of law or fact of public importance, or on any dispute arising out of any pre-constitutional treaty or agreement. Okay. Fifth is court of record is given under Article 129 and 137, reviewing the judgment of its own and other courts and recording them for future reference use. Okay. Court of record under Article 129 and 137. Power of judicial review is not mentioned anywhere, but it is implicitly mentioned in Article 33. And Iyer Kohli case 2007 says no blanket immunity for the judicial review to the 9th schedule. So this is all about Supreme Court.